Do you have will, trust, or estate plan ready? 64% of American family don't have will in place where they can instruct who's guardian their children, what to do with their medical decision, and their will when they pass away. Hi, this is Rosie. Today I will present a guest. Glen Wagstaff is an estate planner lawyer. He will explain it to us what is estate planning, when you need it, what's the difference between will and trust. So Glen, can you explain it to us what is estate plan?
Basically, estate planning is making sure that you have the right documents in place in the case of emergencies. And everybody thinks that you have to have a large estate, millions of dollars, maybe a mansion before you do estate planning. But the reality is that everybody has an estate. And, I always share this story to kind of illustrate that. My sister was studying in her second year of college. She wasn't married. She didn't have any kids, didn't own any property. Most people at that point in her life would have said she didn't need an estate plan, but she found herself unconscious in the hospital. And the hospital called my parents and they asked them if they had a medical power of attorney or a healthcare directive or anything like that. And of course, my parents didn't. And so they said, well, we can't tell you anything, but your daughter's here. And why does that happen? Because there's a law called HIPAA, right? And HIPAA prevents them from sharing your private medical information unless they have something in writing from you authorizing another person to receive that information. And so even though, they were her parents, once she's 18, she's an adult, right? So they had to drive for 2.5 hours to the hospital. And luckily, when they got there, my sister was conscious and she could give permission and everything turned out okay. But those are the situations that get scary, right? Sometimes we imagine that these things are automatic between ourselves and our spouse, but that's not the case. And so if you go to the bank and you want to access a bank account that your spouse is on, but you're not on, they're not going to give you access to it because you're not authorized to have access, right? And so in order to be able to actually, get access to things, make decisions, be able to step in when needed, you need to have the right legal documents in place. Because if you don't have the right legal documents in place, then everything requires going through the court system. And so, in the case of incapacity, the court system would be, getting a guardianship or a conservatorship. In the case of death, somebody passing away, then the court system would be what we call probate. And that can be expensive. It can take a long time. It can be, very stressful for the family. And so most people want to avoid that, right? And so the idea of estate planning is making sure that you have a plan in place proactively before those sort of things happen, so that in the worst case scenario, somebody that you trust could step in and manage things without any problems.
So you say everybody need an estate plan, the basic estate plan. What it is, what's included in the basic estate plan?
Basic documents that everybody needs to have basically are, number one, financial power of attorney. And that's, if you're still alive, but you're unable to manage things for yourself, your financial power of attorney allows somebody that you trust to step into your shoes and to be able to make decisions and manage assets and take care of things on your behalf.
Does that come with the will, the durable financial power? Does it come with the will when you make the will, or that's a separate piece of paper?
It's a separate piece of paper, but generally when you do it, you would do both of them together.
Oh, okay.
Yes, so the basic estate plan that you have, it is include this power attorney.
Oh, it is? Oh, okay, great.
Yes.
And then along with that, you would have your medical directives or your healthcare power of attorney. And basically that's, documents that allow somebody to make medical decisions for you. And your plan also includes that. And then once you have children, and especially when they're minor children, then it's important to nominate the guardian for your kids in case something happens to you. Because if you don't nominate the guardian, then the state, the law is that any interested party can nominate themselves to be the guardian for your children. And sometimes that's, not the right people, right? And so in order to have some control and to be able to, make that decision, you would want to put it in writing. And the place you do that is in your will. So in your last will and testament, that's where you can nominate the guardian for your children. So your will does three things. It lets you name the person who will be responsible for managing and administering everything if something happens to you, if you pass away. It lets you decide how things are going to be divided and who it's going to go to. And then it lets you decide who's going to be the guardian for your children.
What's the difference between will and trust? When you need will and when you need trust?
So if you have a house and you have kids, then that's when we recommend that you have a revocable living trust. And the reason is because if you just have a will, your will has to go through the probate process. So every will have to go to court, and the court validates what your will says. They'll follow what the will says, but it still has to go to court. And if you have a revocable living trust, then you don't have to go through the court system. It can avoid probate.
What's happened if you don't have will and you have a children and you pass away?
There was a couple that went for the weekend down to Mexico. They lived in San Diego and they were returning from their trip. They had two young kids that they left with grandma. Grandma had helped raise them ever since they were little. And the couple was in a car accident and they both died. So grandma expected that she was going to be the guardian because she helped raise them. She was taking care of them when the parents died. She knew that that's what they would have wanted. So she nominated herself to the court to be the guardian. And the court said, we can't give these kids to you. You live on Social Security. You live in a one-bedroom apartment. You can't take care of these kids. We're not going to give them to you. So the kids had to go to the foster care system for 2 months or 2.5 months while the family nominated different people to be the guardian. And finally, one of the aunts was appointed as guardian. And the reason that she was appointed was because she had a good job. She was single. She never had any kids. She never wanted to have any kids, but she had a good income. And so what kind of a life are they going to have, right? And grandma was heartbroken. That's not what the parents would have wanted, but they didn't have anything in writing.
Mm-hmm.
So if she doesn't have a will, any interested party can nominate themselves to take care of her kids. If she doesn't have a will, everything's going to go through the court system. It's going to take 1.5 years. It's going to cost thousands of dollars, and it may not turn out the way that they want. And in the end, the court's going to want a report every single year until the kids are 18 of what was done with the money. So if they have a proper plan in place, if they have a trust, then they can avoid all of that.
What happens if you have an asset and you pass away without a will? How long is the probate will take?
In California, it can take a long time. Right now with COVID, it can take even longer. On average, we're seeing 3 to 6 months for somebody to get appointed and to be able to have control over the assets. And then it takes maybe another year to close the probate. But we've seen situations, even not that complex situations, where nobody's fighting, and it takes 2 to 5 years to complete a probate. So it can take a long time. So again, probate can take a long time, especially in California. They have statutory fees, so it can be very expensive. Right now, because of COVID, it's taking even longer, but in general, California courts just take a long time. And it can cause a lot of family stress, right? Because you're already in court, so in order to have problems, delay the process and everything, they don't even have to fight it. They just have to not be responsive. And then it takes longer, right? And so it can cause a lot of family stress. And then it's also a public process. And so most people prefer to avoid that.
When you need a will and when you need a trust.
So the will
is not enough. If you have a property, definitely you need the trust.
That's right. Yeah.
So the will not cover if you have a property or a business, will not cover that.
So generally,
Mm-hmm.
the cutoff is if you have real estate or
Mm-hmm.
if you have over 150,000 in value in your estate,
Okay.
then it still has to go to probate. Yeah. So then the last thing is just an explanation how the trust works. So when you set up a trust, the idea is that first we, first we set up the trust and you have somebody in charge of managing the trust while you're able to, that's you, right?
Mm-hmm.
If you're married, maybe you and your spouse, and you can manage everything just as if you owned it personally. And then the trust has the directions for how it will distribute. So if you want to leave it to your children, you can put the instructions on what age they receive it at, how they receive it, what they do with it, and so on. And then when you set up your trust, it's not enough to just have the trust. You actually have to put the assets into it. So if you have real estate, we transfer the title to the real estate. If you have, all your personal items, we assign to the trust. If you have accounts, we put beneficiary designations on the bank accounts or the insurance or the retirement accounts so that it flows through the trust.
I have a question. So I do have a saving and retirement account. My house is already in the trust using a legacy seal. So the next step is I call the insurance and the bank statement and etc. to move to trust.
Yeah, you don't have to change the title. You don't have to change the ownership. You just put the beneficiary designation. Yeah, so when you set up your trust, then you also want to make sure that everything gets put into the trust. So you would transfer title, to the house, to, accounts. You wouldn't have to, put the ownership in, but you just change the beneficiary designations. But the idea is for everything to flow through the trust, because then the trust has the instructions on who it's supposed to go to and how it's supposed to go to them. Yeah, so a revocable trust is the trust that we normally use for avoiding probate and for planning for the future and that sort of stuff. And basically it means that you have all the control, just like as if you own it yourself. So even though it's in the trust, you can put property in, you can take property out, you can get rid of it if you want to.
Mm-hmm.
When you do an irrevocable trust, you have to give up some control and you don't have 100% control anymore. But in return, you get protection from, sometimes for taxes, sometimes for, protection from lawsuits or from creditors or planning for benefits. And so we only use those when somebody needs, for some reason, they need to use that sort of trust.
So can you give us example, like what is the case for irrevocable trust planning?
Well, like we talked with the guy earlier today, and he wants to plan for Medicaid, Medi-Cal benefits. He has several $100,000 in value in his estate, but he's worried that he's not going to have enough to be able to pay for long-term care needs. So he wants to get the assets out of his name so that he can qualify for benefits if he needs them. We use an irrevocable trust to do that. But he has to give up the control, maybe put one of his children or one of his siblings as a trustee. And then it won't, he doesn't own it anymore. Now it's owned by the trust, and he'll be able to qualify for benefits later.
So if you want to qualify, like when we get older for Medicare or for Medi-Cal, that if we have something on our name, we're not allowed to get it?
Yeah, so Medicare is the program that you pay into with Social Security.
Yeah.
So that's a different program. But if you need long-term care, you can only get Medi-Cal if you have less than $2,000 of value.
So Medi-Cal is for low-income people to get help from the government to get the health benefit.
So you have to, remove the rest of the value from your estate if you want to try to qualify.
Let's say we have all this and we do get long-term care. and I do retire and I'm getting money from Social Security and I have long-term care insurance, will Social Security tell me, oh, you have money coming in, we're not going to pay, it's going to affect my Social Security? Is that true?
It won't affect your Social Security income now.
So the long-term
Social Security income you receive regardless.
It's regardless. It won't affect it. Okay. It's not going to say, oh, now you have insurance, long-term care, you go use your insurance, and then when you're done, then we'll kick in. It's not like that, right?
Right. So for long-term care needs, maybe it would be like that for Medi-Cal, but it wouldn't be like that for your security, no.
Oh, okay.
Yeah, so most people don't think about it until they're like in their mid-60s for that sort of planning. Yeah, so do you own real estate?
Yeah, we don't own our house, but we purchased it and now we're paying mortgage. And I think our house is the only thing that is big enough that we own.
That would be the recommendation would be to have a revocable living trust. No, just a regular revocable living trust, you would want it now because it's going to protect your kids when it happens to you, and it's going to avoid the court system.
Okay, so when I do go online and I want to get my own will and trust, it has to be a revocable living trust?
No, the one that you would get online is the one you need. It's not going to say revocable living trust, but that's what it is. Yeah, so that's some of the basics. And then, when you set up your trust plan, it's good to not just do it once and then forget about it the rest of your life. It's good to review it every few years. We recommend every, 2-3 years to review things. And just to make sure that it's still addressing your needs and also that you haven't forgotten anything that should be in there.
So here is the conclusion. Everybody needs a basic estate plan. Basic estate plan is include durable power attorney, living medical power in case you need admitted to hospital and you are unconscious, and also have the last will or trust. A little background about me. I don't have a parent since I was really young, so I'm very independent and I am a self-made. I do research. I want to do my will and trust, and it costs so much money when I try to get it through a lawyer. And I found there's a way that I can save money and work as the same as a lawyer, which is online based. The tools that I use is Legacy Shield. The system is simple, secure, and smart. I use it myself because it's affordable. At home, you can put the information at your pace without an error, and there's an AI proven. And also is overseen by 7 attorneys in Legacy Shield Professional Network. Now, on the basic estate plan, that include last will, testament, medical finance power attorney, advance, directive, and HIPAA compliance. And this is all in one secured online base. You can set your notifier, authenticators, and the recipient of your beneficiary. The best part is cloud access and is secured. Lifetime storage. Legacy Shield, partnering with Superhero in Training, offer basic estate plan for only $65. When you pass and you don't leave will or trust, there will be conflict and confusion. Without proper will or trust, your family have to deal with probate, which costs emotional roller coaster money and time. If you're going to leave a legacy, mark a mark on the wall that cannot be erased. Maya Angelou. If you are interested, please let me know. For the basic estate is $65, and then if you want to upgrade it later is $650 for a trust, and with the lawyer additional doing the paperwork for the county is another $100. Let me know if you have any question. For advanced planning, or if you want more information that the basic estate or trust cannot do, for example, for kid with the special need or the second married will or trust, you can contact Glen Wagstaff, Glen at intervivosplan.com, Glen at intervivosplan.com. Just mention you get the referral from Superhero in Training, so you will get a special price for legal advice. And I think everybody need basic estate. And if you have asset more than 150,000, you need a trust. I also included a guide to a basic estate planning. If you want more information more about estate planning, you can download the basic estate plan information through my website, and the link is down there. And if you want to know more about me or about my service, you can go to my website, superherointraining.com. I hope this information helpful. Please leave a comment, like, and forward if you think somebody need this information. If you have any question, you can email me and you can contact me. Have a wonderful day, and don't forget, be a hero today for someone.